Okay, I've been asked a lot about this, so I want to go over it with you. Most of the time I talk to people, it's one-on-one in person, so hopefully this will get around to enough people. Okay, it says are cops obligated to investigate a case? Okay, a detective has a legal obligation to investigate reported crimes, meaning that they must actively pursue leads and gather evidence when a criminal offense is brought to their attention. However, the extent of the investigation can vary depending on the factors like severity of the crime, availability, resources, and credibility of the report. And not every reported incident will warrant a full-scale investigation. Key points of detective obligations: to investigate crimes, duty to serve and protect law enforcement. Officers include detectives, have a general duty to serve, protect public, which includes investigating reported crimes when appropriate. Discretionary aspects: while obligated to investigate, detectives have some discretion how thoroughly they pursue a case based on factors like seriousness of the crime and evidence available. Reporting requirements: detective must often document their investigation actions and findings according to department policies. In some cases, if a detective fails to properly investigate a reported crime, they could face legal consequences if deemed a significant breach of duty. Okay, so it's rare that you will find that anybody actually investigates a crime. Okay, for instance, a case that I was involved in, police arrested me, accused me of being somebody I wasn't. I told them who it was, gave them the name, the state they lived in, and everything about the individual that was supposedly involved in an incident. And they failed to investigate. You know, and they knew they were legally obligated. And, that's why the state's attorney and lawyers for the defense didn't call the detective, because I wanted him questioned about his investigation. Did he investigate this other person? Okay, so detectives are obligated. Okay, there's a lot you can read on that, but yes, how the police conduct criminal investigations before arrest. What to do if police fail to investigate a crime. Mandatory to participate in investigations. How the police conduct criminal investigations before. Okay, so there's a lot of answers here for questions you may not even have asked. Okay, but people ask me plenty of times, are cops, specifically the detectives, are required to investigate the crime to see if you are actually the individual that committed a crime or if a crime was committed. Okay, and many times they're anxious to close a case than actually solve the case. Uh, so many times I've helped people with because the cops failed to investigate. Okay, and people also ask, uh, okay, says our attorneys are required to investigate. Attorney has a legal and ethical duty to conduct a reasonable investigation into their client's case, which means gathering relevant facts and evidence to properly represent their client to ensure the legal claims are well founded. Failing to do so could result in disciplinary action against the lawyer, which is a violation of rules of professional conduct of failure to do so. Okay, so yes, your lawyer is legally obligated to investigate the crime. Professional responsibilities, most judiciary rules of professional conduct mandate that lawyers exercise due diligence and conduct appropriate investigations based on circumstances of the case. Scope of the investigations include reviewing documents provided by the client, interviewing witnesses, researching applicable laws, and exploring potential legal theories. Client disclosure: while the lawyer relies on information provided by the clients, they still have a duty to investigate further if there are red flags or inconsistencies that suggest potential issues. Avoiding frivolous claims: an attorney cannot base a legal claim on unfounded accusations or theories without conducting a proper investigation, which this could lead to sanctions or disciplinary action. Potential consequences for not investigating adequately: malpractice claims. If the client suffers damages due to the attorney's failure to properly investigate, they may be able to file a malpractice lawsuit. People, there are a lot of malpractice attorneys out there, and you could actually break attorneys because in most states they're not required to have legal malpractice insurance, so most of them don't. So if you sue them for legal malpractice, you're going to break them. Disciplinary action: bar association can investigate and sanction lawyers for failing to meet their ethical duty to conduct a reasonable investigation. Okay, and let's see. Three, eight. Okay. So it's even if in a criminal case, in any case, it's every lawyer's duty to investigate on both sides, all sides. Okay, I use nothing but legal sites and I just cite the law. Okay, nothing I say is a matter of opinion. If you want to argue with me, argue with the American Bar Association, your state bar association, your Supreme Court, so on and so forth. Okay, now this rarely happens, but check this out. Oh man, fuck. Is it still recording? Let's see. Hello? Okay, we're still going here. Okay, oh, okay, yeah, here it is. Okay, this is from the Rules of Professional Conduct, Rule 3.8, Special Rules in the Prosecutor. Every state and federal courts have this rule. Now look up in the interest of justice, you can actually motion for dismissal on the interest of justice because you had no clue the Rules of Professional Conduct, Code of Judicial Conduct existed. Then hold them to the letter of the law, meaning they have to do exactly what is written, word for word, to the letter in the Rule of Professional Conduct and the Code of Judicial Conduct. The rule of a prosecutor are unique and they have both powers and duties. Lawyers do not. This does not mean prosecutors are any better or worse than other lawyers, but it does result in many misconceptions about the prosecutor's role in the criminal justice system. The quotations contained in this page are independent and shed some light on this role. The duty of a public prosecutor or other government lawyers to seek justice, not merely to convict. Okay, so that's where we're going to jump in over here. Prosecutor in a criminal case shall refrain from prosecuting a charge the prosecutor knows is not supported by probable cause. So they have to investigate the case to make sure it's not a fraudulent and frivolous claim. Okay, if it is, then they have to dismiss the case, no probable cause. Okay, so that's the first thing you want to do with a criminal case is a probable cause hearing, which most lawyers won't bring it up. I've fought with public defenders helping people in criminal cases because they refuse to have a probable cause hearing. I had judges yell at me, get mad at me without saying a word, me being cited for contempt of court without saying a word because I helped these people make, and they demanded a probable cause hearing. Quite a few of them had their cases tossed out because of no probable cause. Okay, B, make reasonable efforts to ensure that the accused has been advised of their right to and the procedure of obtaining counsel and be given reasonable opportunity to retain counsel. A lot of times, if you get arrested, the cops want you to sign a confession, and they'll bring an attorney. I quite a few times I got arrested or picked up, asked for an attorney, and they never brought in a public defender or attorney of my choosing. It was always the state's attorney, which is illegal for a state's attorney to even speak to you without an attorney present. Okay, make reasonable evidence to ensure accusers have been advised of the right and procedure of obtaining counsel has been given reasonable opportunity to obtain counsel, not seek to obtain unrepresented accused of a waiver of important potential rights such as a right to a preliminary hearing, and they will do it. They will tell you you don't need it. Make timely disclosure to defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigate the offense in connection with sentencing. Disclose to the defense and to the tribunal all unprivileged mitigating information known to the prosecutor, except the prosecutor is relieved of this responsibility by protective order of the tribunal. E, not subpoena a lawyer in a grand jury or other criminal proceedings to present evidence about a past or present client unless the prosecutor reasonably believes the information sought is protected from disclosed or applicable privilege. The evidence sought is essential to the successful completion of an ongoing investigation. There are no feasible alternative to obtain the information except for the information necessary to inform the public nature, the extent of the prosecutor, and serve legitimate law enforcement purpose. Refrain from making extrajudicial comments that have substantial likelihood of heightening public condemnation of the accused, and exercise reasonable care to prevent investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case from making extrajudicial statements. The prosecutor would be prohibited from making under Rule 3.6 of this rule. G, when a prosecutor knows of credible and material evidence creating reasonable likelihood that a convicted defendant did not commit the offense for which the defendant was convicted, or prosecutor shall promptly disclose that evidence to the appropriate court of authority, and if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless the court authorizes delay, and undertake further investigation or make reasonable efforts to cause an investigation and determine whether the defendant was convicted of the offense the defendant did not commit. When the prosecutor knows of clear and convincing evidence establishing that the defendant in the prosecutor's jurisdiction was convicted of an offense the defendant did not commit, the prosecutor shall seek remedy to conviction. Okay, so it's not only the prosecutor's job to investigate a case to see if it's worthy, to proceed, if there's probable cause to proceed. So it is their duty to investigate. And if they know there's exculpatory evidence, they're supposed to say, hey, this person who came in here and had this other person arrested lied, they committed perjury, they lied to me, they're here lying in the court. See, due process is a double-edged sword. Now that swings both ways. Okay, so don't forget that. So anyway, let's go back here to my page, Legal Reform. And see, I put some comments here. Kim Fox, before while she was state's attorney, she established a special little office that specifically overturns wrongful convictions. And so I put it in the comments here. Okay, sorry about that. Officer, Attorney General, Conviction Integrity Unit. The Attorney General's office addresses questions of wrongful convictions. So you'll want to not only contact the state's attorney's office, because Rule 3.8 says it's their job to exonerate you if you present them with exculpatory evidence. It's their job. So if you're worried about hiring a lawyer, save the expense and go to the state's attorney's office. Just don't do your job. Don't forget to take a copy of the Rules of Professional Conduct with you and point out Rule 3.8. That's your job. Not asking for no favors. Remember the oath you took, serve and protect the Constitution. Well, that Constitution was written to serve and protect me. By me, I mean as in we the people. So you're literally supposed to serve and protect me from abuse of power. That wrongful conviction was based on withholding exculpatory evidence. They violated the oath by doing that. And by violating the oath, they not only decimated the Constitution, they desecrated and then defecated on it by denying me my right to due process. That was a conspiracy to deprive rights under the color of law, which is illegal. And you know the law behind that. I've got other videos on that. Okay, conspiracy to deprive rights under the color of law. You can look that up. That's a legal term. Okay, so Kwame Raoul is also Attorney General's office. Okay, so they're going to help you too. Okay, so that's here in Illinois. Every state should have that. And this is another. It's the same one. Kwame Raoul's office. Okay. It would be in the public interest for every state to be doing this. So, that's how you maintain the public trust. I'm specifically talking about the public trust doctrine, the public trust doctrine. Let's go back over here. Okay. Um, okay, I talked about this in some of my other videos. The trust doctrine is a legal principle that states that certain natural resources like navigable waters, tidelands are held in a trust by government benefit for public, meaning that the government has a duty to protect and manage these resources for use and enjoyment of all citizens, including access to recreation, fishing, navigation. Essentially, the public owns these lands and the government acts as a steward on their behalf. Key points: origins, doctrine from English common law. Okay, what does public trust doctrine do? Common public trust doctrines protect sovereign lands such as tide. Okay, that's not happening. That's why you got so much pollution. Nobody's, doing this. I mean, if people are complaining about, your water in Colorado and California, they're letting all these big companies pump it out. And, the general public isn't getting it. No, that's violating the public trust doctrine. That's against the law. Remember, the public trust doctrine is within the Constitution, and the Constitution was created to tend to the needs of the many, not the needs of the few. Okay. Uh, Public ducks maintain a common right to fish in navigable waters. What are obligations of the public trust? The essential obligations of the state is to manage the tidelands for the benefit of all the people. The state uses that not to accommodate, promote, foster, or enhance the statewide public need for essential commercial services for the enjoyment of the tidelands are not appropriate use for public trust lands. Okay, what is an example of a public trust? Examples include hospitals, supermarkets, department stores, and local governments and public office buildings that serve rather than specifically trust-related functions. Okay, that includes the legal system. Okay, uh, criminal records. What disqualifies you from public trust? Felonies. Okay, I don't care about that. Why is a public trust important? Public trust is the pillar of democracy, fostering debate and participation, encouraging compliance with the law, and facilitating reforms. What is the public trust doctrine, Magna Carta? I mentioned the Magna Carta before. That starts with the history of the rule of law. Magna Carta specifically condemned the interference with public access to navigable waters, bodies of water, prevented the king from giving favored noblemen exclusive rights to hunt and fish in certain areas. You really got to think about that, people. Who's enforcing that? What is the meaning of the public trust? An organization that manages money for a particular charity or group of people who are poor or in need of help. The library is a public trust funded by the taxpayer. Okay. So people, politicians, screw at libraries because they're, handing out books. That's the public trust. Okay. The politicians are there to maintain it, not to deny you access to it. Why does the public trust? Okay, let's see. Okay, we find the negative perceptions of the economy, scandals associated with Congress, and increasing public concern about crime each lead to declining public trust in the government. Uh, what is the breach of public trust? Breach of public trust means violation of provision, state constitution, or this part which establishes the standard ethics, conduct, and disclosure requirement. Okay, remember the legal system is part of the public trust. What are the 5 levels of security clearance? How hard is public trust clearance? What is considered a public trust? Public trust term referring to any public property which belongs to the whole of the people. Okay, that means the entire judicial system. Okay, that's part of the public trust. Is Magna Carta right? Magna Carta recognized rights that are already existed. However, the Magna Carta, these rights were for free men, and these times most people are peasants. They meant that they aren't free because they serve landowners. If you're applying for a position with the federal government, it's important that you know the U.S. You must be a U.S. citizen. Okay. 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 Okay, so I just want to make sure you know, uh, the legal system is part of the public trust. All right. A lawyer is a member of the legal profession, is representative of clients, an officer of the legal system, and a public citizen having special responsibilities for the quality of justice. As a representative of clients, a lawyer performs various functions. A lawyer provides client with informed understanding of the client's legal rights and obligations and explains their practical implications. As an advocate, a lawyer zealously asserts the client's position under the rules of the advisory system. As a negotiator, a lawyer seeks a result advantageous to their client, consistent with the requirements of honest dealing with others. As an evaluator, a lawyer acts examining a client's legal affairs and responding about them to clients or others. In addition to these representative, let me just go down here. You can read all this for yourself. I just want to. A lawyer's responsibilities, representative, is a legal system and a public citizen, thus when opposing party as well. Okay, the nature. So it's got to be done. Okay, legal. Okay, the legal profession's relative autonomy comes with special responsibilities. Self-government profession has responsibility to ensure that its regulations are conceived in the public interest, meaning what they're supposed to do, what's in your best interest, and not furtherance, parochial, or self-concerns of the bar. Every lawyer is responsible for the observance of the rules of professional conduct. Lawyers should also aid securing the observance by other lawyers. Neglect of these responsibilities uh, compromise the independence of the profession and the public interest, which it serves. Remember, it's supposed to do what's in your best interest, not in the interest of the bar. Okay, lawyers play a vital role in preservation of society. Fulfillment of this role requires understanding of lawyers' legal responsibilities, legal system, the rules of professional conduct when properly applied serve to define that. Okay. Okay. I'm just trying to get this together as quick as possible, not spending that much time. Uh, okay, so we started out with it's detective or cop's right or legal obligation to investigate a case. It's your lawyer's legal obligation to investigate the case to make sure these are legit charges. It's the state's attorney's legal obligation to see that everything's legit and nobody's BS. And, that's where probable cause hearing comes into effect. Not only in an arrest do they have to establish probable cause for arrest, but in court they have to establish probable cause to proceed. Okay, and that requires reasonable knowledge to make an informed decision, to give informed consent. If you don't know the rules of professional conduct and the code of judicial conduct and the lawyers, whether it's in criminal court, your lawyer, the state's attorney, the judge didn't sit back and discuss it with you, let you know that this is your right to due process. This is what gives definition to effective assistance of counsel guaranteed in the Sixth Amendment of the U.S. Constitution. The lack of effective assistance of counsel is the lack of a fair trial, which is the lack of due process, which is a lack of your ability to have a life with liberty and pursuit of happiness. I mean, if lawyers and judges were honest about this. Okay? So it's everybody's everybody's legally obligated to investigate the case before anything can proceed, and you usually don't get discovery because they don't want you going over discovery in case you might find out that it's a conspiracy to deprive rights under the color of law. Okay, because it's mandatory to report misconduct in the rule of professional conduct and the code of judicial conduct, and nobody abides by the rule of professional conduct or the code of judicial. Nobody abides by them, enforces them, or reports. And failure to report is misconduct in both the rules and the codes. Okay, so I'll get in more detail about that. But as far as, anybody having a legal responsibility to investigate to see if it's worth proceeding, it's everybody's legal obligation to investigate. Okay, and don't forget that I showed you in Illinois. I'm in Illinois. That's why I brought it up. But it's the legal obligation of every state's attorney in every state, uh, to do. Some states remove 3.8 from their rule of professional conduct, but remember that was in the interest of the bar. That was not in the public interest, which violates the rule of professional conduct. Each state is responsible for using the model rule of professional conduct, which you'll find on the ABA website. That's a federal edition. And remember, I told you any law repugnant to the U.S. Constitution is null and void. So them saying they have the state's rights to limit, to minimize your right to due process is totally illegal. Okay, that was in the interest of the bar, not in the public interest. Okay, so feel free to match up. And then you also want to contact the Department of Justice Civil Rights Division, because these are violation of your civil rights. You look up a right to a quick and speedy trial. You know how many people went to prison? Lack of a quick and speedy trial. I watched on the news, and I've witnessed and tried to talk to people, and I've witnessed them sit for 2 years, going on 3 years, waiting to go to trial. And then they find out, the state comes and offers them, hey, we're going to give you this cop out. We're going to give you 3 years. You sign this, we'll ship you off to prison. You'll sit there for a month and you'll get out. And the guy's like, okay, well, I almost did the time anyways, might as well. But legally, he was deprived a quick and speedy trial. Nobody even mentioned it. Nobody brought it up. And since he didn't ask for it, the judge wasn't, nobody was going to bring up, nobody, as long. So you have any of your constitutional rights. If you don't demand them in court, you're not getting them. All right, this is Pops from Legal Reform. I just thought I'd let you a little bit more. I'm trying not to make this too long. 33 minutes. I'm going to cut this short and get into another video because there's some long ones I got to go through. They could take up to 2 hours, and you really need to know what due process is. There is no due process if you didn't have a fair trial, and you didn't have a fair trial if you didn't have effective assistance of counsel. Virtually effective assistance of counsel doesn't exist if nobody's abiding by the rule of professional conduct, the code of judicial conduct, if nobody's enforcing the rule of professional conduct, the code of judicial conduct, if nobody's reporting any violations and said rules and codes. Effective assistance of counsel does not exist, because effective assistance of counsel is a double-edged sword. Effective assistance of counsel is described in the rules of professional conduct and the code of judicial conduct, and those are the legal obligations of all lawyers and judges. Okay? All right, thank you. God bless. Have a good night. I said, the only real chance you'll ever get a fair trial is if you get a law degree yourself and become a lawyer. Other than that, you're lost. But let me help you, though. There's a lot of stuff on legal reform. I'm teaching you what you should know. And as long as you use it, it's quite easy to prove a conspiracy to deprive rights under the color of law. Okay? and I kind of shortened it for you here. Have a good night. Thank you. God bless.